All right, so here we are for the first half of issue spotting. Issue spotting is a different kind of approach to exams than we've talked about previously. Issue spotting exams provide you with a question, but the call of the question may be something as vague as write about the issues you see, or discuss all issues where person X is involved, something like that. And for these kinds of exams, you have to understand a little bit, you have to be a little more aware, rather, of what's arising, how it might arise, how to pick it out, what to look out for. So that's what we'll be talking about today. What's an issue? Oh, you know already. But let me talk about it from this perspective. If you take a step back, it's really a question raised by the interaction of facts and law. Here's a weird factual circumstance, like most exams are. And it triggers, essentially, certain aspects of the law for you to talk about. And oftentimes, it's with regards to even one of those elements or rule component that you'll need to talk about. So, for example, if the main question is, can Jane sue Joe for false imprisonment? And as part of that analysis, you'll have to determine if each of the rule components for false imprisonment are satisfied. And that's where issues arise commonly. Some are very easily satisfied, some require more discussion. But that's often where the issues arise. And really, practically, particularly for exams, it's all about giving you a hook to talk about facts legally. And when the professor provides you with the call of the question, they kind of drop it in your lap. But with issue spotting exams, it's a little more wide open. Okay, let's get down into it. What is issue spotting? Well, it's identifying legal issues within a fact pattern for which you can make colorable arguments. In other words, arguments that would pass the laugh test. And by that, I mean if you tell one of your classmates what you would argue and they would laugh at you, you probably don't have a colorable argument at that point. And it's an argument that you think a judge would entertain. So if you could stand up in court and make the argument to a judge with a straight face, and you think she would not tell you to immediately sit down and stop wasting her time, then you may have a colorable argument. But those are sort of thought experiments I would go through to sort of evaluate whether or not you have a colorable argument. And what's that matter? Well, if the argument isn't reasonable, if it's outlandish, you don't want to be writing about that, especially on an issue spotting exam. Issue spotting exams oftentimes have so much information in them that and so many issues embedded in there by your professor that if you're pulling crazy ones out of the air, you should probably take a step back and reread the fact pattern to figure out what you're missing. Because there's going to be low-hanging fruit, higher fruit. I don't know if the analogy extends to high-hanging fruit, but anyway, there's going to be easy things and hard things on the exam, of course, and there aren't going to be crazy things, things that aren't colorable. You don't want to raise those on an exam. They're wasting your time. You probably annoy the professor. Skip it. All right, well, how do you issue spot? First step, of course, it's law school, right? Know the law. So that means knowing the definitions, knowing the rules, and understanding the relationship between legal principles. And by that I guess that's what we're all here to do. But really, by that in particular, I mean that if you have defenses and primary causes of action, for example, in torts, you want to know which defenses work for which causes of action. You have to understand the relationship between those two legal principles. it and memorizing that is there's different tricks and rules. We've talked about forced recall and the like, flashcards. So you could do lots of things to understand that. But really, it's the synthesis that you're doing by creating your outline, doing practice questions, creating note cards, and having study groups, and going to class, of course, that permits you to really develop and deepen your understanding of that relationship between legal principles. Second, particularly for issue spotting exams, you have to study the facts. What facts line up with rule elements? And I mean that in a general sense. When you first see a question, there may be an intent component, for example. That doesn't implicate any particular tort, but it is something you have to, take in mind when you're talking about a lot of different torts. So there's an intent. Maybe there's an awareness component, which could be relevant, of course, to assault, but in ways also false imprisonment. And, that awareness is something you want to see. If it's jumping out at you in the fact pattern, well, it's probably relevant and probably something that you're going to want to talk about. So you want to line it up with a rule element so you can trigger which collection of rules that you'll be talking about. So, if somebody is hit by a ball and they were unaware, then, boom, battery assault. We know we're talking about that. And those are the issues you're going to want to write about. So you want to annotate or write out relationships and transactions. Because, and I mean literally draw, A for party one, or, P and D for plaintiff and defendant, write arrows with numbers on top if there's a contract, like arrows with an act on top if it was a tort. Because once you lay out those kinds of relationships between the parties and the transactions between the parties, you will identify issues. Because that will just put it all on paper in front of you, stripped of extraneous information from the fact pattern, just the relevant stuff for these two parties and how they interacted. And that is the basis for what you'll be writing about. The other thing I would suggest is to slow down and think a little bit, particularly right after you read the fact pattern. Sort of mull it over, and I'm not talking about, an hour. I mean just for a couple minutes. Just think, go through the fact pattern in your head, play through what you know about causes of action, play through what you know about contract formation and enforcement. Although I don't know that you've gotten to enforcement yet, but interpretation, all various aspects of contracts. You want to see what lines up, what fits. And to do that, I think you need to take a step and back and think a little bit more about the fact pattern. This is something, I don't know if I've said in this class, but I definitely have said it this semester elsewhere, and I say it most semesters. Anytime you write a legal document, the first thing to do is to think of your audience and your task. What is this document designed to achieve? And how can I make sure that the document achieves that is by thinking of how to communicate that to my audience. If you're writing for a judge, it's one thing. If you're writing to an arbitrator, it's another. If you're writing to a client or opposing counsel, they're all very different things. They will accomplish different things, and you write with different tone and content for that audience, depending on the purpose of your legal document. In patent applications, it's very complicated because you have between a half dozen and a dozen audiences. It makes them very hard to draft, but that's really the first thing you have to do is think about who those people are. For whom are you writing? Here, and exams are a legal document, you're writing for your professor who will be grading this. And I said this briefly last lecture, but I'll repeat it now. Your professor will, I think in most every instance, have the whole class's exams to grade. So if they have 4 questions, let's say they have 5 questions on their exam, we're talking about hundreds, 500 questions to read plus. So remember that they are reading a bunch of the same things over and over. That's not a bad thing. You don't want to stick out necessarily or try to stick out. Instead, you want to remember, you want to make things palatable for them. You want to make it easy to grade because they have a ton to do. They have a ton of these to read. And you want to make it so your exam conveys the relevant information in a way that makes it easy to grade, because a happy grader makes for a happy student. I'll leave it at that. So put yourself in your professor's shoes for a minute. What are they trying to test you on? Your understanding of the law, your ability to apply the law to a set of facts. And they're going to look at the whole semester probably. I mean, they'll tell you specifically what they're aiming for temporally, what slice of time. But most all instances, it's going to be the whole semester. So, keeping in mind what they're trying to test you on permits you to structure your answers in a way that you think would be palatable. I'll give you some tips, but I can entertain any that you might have too. So feel free to email them to me. Anticipate how the issues might appear on an exam. For example, there's a reason I always go to assault and battery in my examples. It's very easy to think about assault and battery. And it's very easy to generate fake facts that you can immediately talk about with assault and battery. Because I've thought about how I would ask questions about assault and battery, there's probably only a half dozen ways you can really get at assault and battery. The ball, horseshoe, sporting balls or items like horseshoes or shuttlecocks from badminton. I don't know. But, regardless, there's only so many ways they can ask you about this stuff. They come in different categories, you might say, but really there's only so many ways. So think about how that could arise. And then when you see it in a fact pattern, boom, you'll pick it up right away the more you think about these. Okay, after you have in mind for whom you're writing, next step is, of course, to evaluate the facts. If there's a call of a question, you probably want to read that first so you have an eye towards what facts are going to be important. But through those two prisms, the call of the question and the audience for whom you're writing, you should be able to pretty effectively evaluate the facts. Your task here is really to look for important facts. They may be called salient, germane, whatever. It's, it all means the same thing. These facts are important. Why are they important? Because you're going to use them in your legal analysis for the question. That's why it's useful to read the call of the question first so that you have an angle, more or less, right, on what you'll be answering. I'll give you an example of how that changes the whole question when we're done with the substantive slides here. So facts are usually, almost always really, divided into the following 3 categories. Background, who are the parties? How do they know each other? What kind of relationship did they have? Were they businesses? Where did they live? Those kinds of things. Necessary facts. They're necessary for what? Oh, of course, for your legal analysis. So that will commonly be acts by parties, transactions between parties, communications between parties. Those are almost always the necessary facts. And finally, red herring facts. They're the kinds of things that you've seen in exams your whole life, but it's also not uncommon to see them on legal exams, depending on your professor. But red herring facts are ones that look good at first glance, perhaps, but really in actuality aren't relevant. So there are things you have to keep your eye open for as you read through the facts. And finally, this is one of those things which you do when you first start undertaking this kind of exam evaluation and practice answer generation that you will get better at and won't need to undertake, with a lot of forethought at that point. You'll be just good enough to pull it off when you read the question. But you're going to want to read the fact pattern with an eye towards what are basic, necessary, or red herring facts, so that you can start lining things up with your causes of action. And the sketching out the relationship between parties often helps with identifying red herrings, just because you will see the elements line up without the use of the red herring. That's usually a pretty good sign that it's actually not the most relevant. So by keeping a running list, I don't mean keep a actually numbered list. I mean keep a diagram where you're relating all these parties to each other and the transactions. Sketch it out. Just keep updating that relationship chart, or whatever you might want to call it, to update your understanding of the facts and what's going to be relevant from the facts. So when you first start practicing issue spotting, try and write down the factual answers to these questions. And again, writing them down as you start is great. As you go through and practice more, that's not something, of course, that you'll have to do. And it's not something you'll do on an exam for the sake of time. But these are the kinds of questions, another way of thinking about this, these are the kinds of questions that you want to ask yourself as you evaluate a fact pattern for an issue spotting exam. All right. So who are the important parties? You have to know that very early in the fact pattern. What's the relationship between the parties? What transactions occurred? Are there really odd facts? For example, if somebody is intoxicated in a law school exam question, it's almost always relevant, right? If somebody's a minor, there's special property, unique property, for example. When you get into criminal law, you'll see conspiracies. Once you start seeing people meeting to commit a crime, bam, conspiracies and all the sundry rules that come along with it. So if there's weird things in some of your tests that you need to evaluate to determine whether or not it's relevant, they look for those in the fact pattern. They can help you identify and sort of orient your answer. What were the important actions? And that sort of ties back to the transactions point, but it is more than that, including acts and for tort within a tort context and communications, all those kinds of things. And how were the parties affected by those actions? Those are all the kinds of pieces of information that you'll want to include in that sketch chart that updates the facts as you understand them. Okay. Take a moment and read this question. Okay. So I imagine, when you first started reading it, we're like, oh, it's a contract question. But those are you who are Civ Pro junkies will also recognize that last sentence may raise an issue of civil procedure. Anytime a question includes a fact like that, it sort of stands out, it's weird, not really related, why are they telling me this? This doesn't have to do with any. Well, maybe it does. Take a closer look at it. Could be a red herring, could be really important. You don't know until you sort of evaluate it carefully. But how do you answer this? You don't know yet, of course. So what if you were in civil procedure? Switch the order of the slides. Anyway, so here's an example for civil procedure. Does Jimmy have standing to sue Richard in federal court? Well, no. Then, boom, you're talking about diversity jurisdiction, amount in controversy, all that stuff. Now, if it were a contracts question, what do you got? Well, now you're talking about breach and whether there was a contract formed and whether that contract was enforceable. So the facts from this tiny fact pattern will give you different answers depending on the direction from which you approach it. And that's why I suggest reading the call of the question first. Okay, for those who listen to the end, if anybody can tell me what the comfy chair is, the comfy chair, the hint there is that it's used as a torture device. You can, if you don't know it, you can find sketches on it. So please write me if you do figure that one out. See you in part 2.